This is Fighting for What's Right with personal injury attorney Barry Doyle. So Barry, if you're going to look for additional sources of compensation, where do you look?
There are two basic places where you're going to look. One of these is at additional levels of insurance coverage. The other is that you're going to be looking at additional defendants to bring into the case.
And how do you go about identifying additional sources of insurance?
Well, there are a few different ways that you handle that. One thing that we look at when there's a significant injury is whether or not there's an umbrella policy available. Now, there are processes that are available for your primary level of insurance to be disclosed by the insurance company, but they aren't really required to disclose umbrella policies. And one of the things that we require in our office when we're settling a case where the primary level of insurance coverage isn't going to be enough to really compensate the client is we demand that the defendant, the at-fault driver, provide us with an affidavit establishing that there is no other insurance coverage available, including umbrella policies. And an umbrella policy would be a policy that covers levels above and in excess of their primary policy. That's something that is very effective in making sure that we've investigated that issue thoroughly, and in some cases that's actually triggered additional levels of coverage that we weren't aware of to begin with. Past that, the other place that we go looking for is an employer's policy. Now, if you are driving your car doing something that's employment related and you get into an accident, your employer is also going to be responsible for any kind of injuries that you may have caused. And there have been a number of cases where on the surface, the person who's driving the car didn't have enough insurance to cover my client's injuries. But after we got digging into the case, we found out that the person who was driving was doing something employment related, and that triggered additional levels of insurance. So just to give you an example, we were representing a lady who was actually crossing the street in a wheelchair, and she was hit by a car. She suffered a number of fractures and really pretty significant serious injuries. The woman who was driving the car had a grand total of $100,000 worth of coverage through her insurance policy with Allstate, but she was also a pharmaceutical sales rep, and she was on her way to a call at a doctor's office, and that triggered the insurance policy for the pharmaceutical company, which was, I think it was $25 million. So there was an enormous amount of coverage that was available above and beyond the primary policy that the driver had, and eventually that resulted in the client getting well in excess of $100,000 more in compensation for the injuries that she suffered from getting hit by a car. If we hadn't done that level of investigation, the client would have not received nearly enough money to compensate her fairly for the kind of injuries that she suffered. Another unexpected place where we've been able to find additional levels of coverage is when somebody's driving a loaner car. So take for example, you bring your car in to get fixed at the dealership, they give you a loaner car to drive around. The law in Illinois is that the insurance tracks the vehicle. So the fact that you're driving a car that belongs to the car dealership means that the car dealership's insurance should apply, notwithstanding anything that you may have said about my insurance will cover this. Typically, those policies that are going to be issued to car dealerships are going to be much larger policies than you yourself will have, and can provide additional levels of compensation for people who get hit by people who are driving these loaner cars.
And Barry, when you're talking about additional defendants, what exactly are you talking about?
Well, there's really two different sources that we're talking about. Number one is in the employment situation, you can actually bring the employer in as an additional defendant in the case. So if you get into a car accident while you're driving for work, your employer can be brought into the lawsuit. Past that, the second place that we really look is associated with the vehicle itself.
So then how can the vehicles involved be an issue when there are serious injuries?
Well, there's really two different ways. One deals with the issue of the repair of the vehicle. If a car had been brought in for repairs sometime shortly before an accident occurred and there was a problem with how things were repaired, or they weren't repaired in a proper kind of way, that certainly can be a reasonable subject of investigation, and if whoever did the repairs did a bad job repairing it, or the repairs failed for whatever reason, that certainly could be an issue in the case. The second way that the vehicle can actually be an issue in the case involves the doctrine of crashworthiness. What crashworthiness means is that cars crashing into one another is a foreseeable part of the operation of cars on the modern highways in America. And cars should be built in a way that people can survive them. In other words, when you crash into another car, you don't expect the car to explode into flames. And cars really are specifically designed to avoid having these kinds of things happen. If there is some type of defect in either the design of the car or in its manufacture, this can be an issue in the case, but it's got to be one of these cases where it really is a truly, truly significant injury. You've got to have the remains of the car available, but potentially it's something that you can look at. And it's something that I've actually only done once in my career. And it was a case where a woman was sideswiped while she was driving down the street. She lost control of the car. She drove into a telephone pole, and she ended up with fractures of basically all of the bones in her legs. And when we went looking at the remains of the car, we saw that all the welds in the passenger compartment had failed. And what happened was that the passenger compartment basically collapsed in on her legs. That was a case where we were actually able to make that into a crash worthiness case because there was a defect in the actual manufacture of the car. It's a rare set of circumstances, but it's something where if you have the type of injuries that would justify it and you have the remains of the car available to you, it may be worth investigation.
That's crazy. Are there any other places you look?
Well, the one other place that we look at under the right set of circumstances involves what's called a Dram Shop Act claim. And basically a Dram Shop Act claim involves cases involving drunk drivers. Illinois has a statute called the Dram Shop Act, and basically what it provides for is that when you are injured as the result of somebody who becomes intoxicated in a licensed liquor establishment, that's the dram shop, meaning a bar or a restaurant, and they go out and they hurt somebody else, then the bar or the restaurant is going to be responsible for the injuries that they cause up to a certain limit, which is adjusted every year for inflation. One of the things that's important to know about Dram Shop Act cases is that it has a 1-year statute of limitation versus the standard 2-year statute of limitations that's involved in most personal injury cases. And you need to be able to identify where somebody was drinking before they caused the accident.
Barry, is there anything else that can be done when there is either little insurance or no insurance at all?
When you have that kind of a situation and you've been in a car accident, there are really two options that are left, and they both involve going through your own insurance. When you have full coverage on your car, you're going to have two different types of coverage. One is called uninsured motorist coverage, the other is underinsured motorist coverage. Now, what uninsured motorist coverage does is it kicks in and provides you with compensation up to whatever your policy limit is for injuries that are suffered as a result of either an accident with a driver who has no insurance or a driver who's a hit-and-run driver, because the law in Illinois regards a hit-and-run driver as an uninsured driver. Either one of those cases, you can be paid by your own insurance company for your damages up to what your policy limits are. Underinsured motorist coverage is similar but works a little bit differently. And how that works is this. If you have more insurance coverage than the other driver that you're involved in an accident with, what happens is that your insurance kicks in and pays the difference between what the other driver has in the way of insurance and what you have insurance up to the policy limits. So let's just take, for example, you get involved in an accident with a driver who has the state minimum, $25,000. If you have $100,000 worth of insurance coverage, what happens then is that your insurance company will pay your damages in excess of $25,000 up to the $100,000 figure total. Underinsured motorist claims can be really kind of technically challenging, even for people who do this kind of work. And I'd strongly recommend to anyone who's looking at a possible underinsured motorist claim to get legal help, because if you don't know exactly what you're doing, you can cause yourselves all kinds of problems in terms of pursuing this kind of claim. But uninsured and underinsured motorist coverage is really the last avenue you have available to you when you get involved in an accident with somebody who has no insurance coverage at all, a hit-and-run driver, or somebody who really has inadequate insurance to cover the kinds of damages that they cause.
Thanks, Barry. This has been Fighting for What's Right with personal injury attorney Barry Doyle. For more information on car accidents, check out more videos at fightingforwhat'sright.com.